there are moments when you just got to say something. Social convention be darned. For example, let's say you're interviewing the President of the United States. Now, willy-nilly, he or she, thank you very much, is deserving of a modicum of respect because, as I say, willy-nilly, the President is not only the head of government, the person who climbed to the top of the greasiest pole in American society, but is also the head of state, the figure in whom is embodied the notion of nationhood. It's just that way because we made the mistake of getting rid of the monarch. You know, a meaningless person to whom we attach that kind of awe. So, okay, arguably, the President of the United States is owed at least that modicum of respect. Still, there are times when you just got to say something when you're interviewing the President of the United States. President of the United States. Case in point, this week, Charlie Rose on PBS interviewing President Obama, talking about the assurances the President was giving that the scandal that has erupted around the reports of NSA surveillance of our phone calls and internet traffic, the reassurance is that there's nothing to worry about. And then Charlie asks this.
Should this be transparent in some way?
It is transparent. That's why we set up the FISA court.
He sounds impatient, and the only real rational response should have been, with all due respect, Mr. President, are you kidding? Case in point, from today's Washington Post. The public is getting a peek into the little-known workings of a powerful and mostly invisible government entity. The court whose secret rulings have in effect created a body of law separate from the one on the books, one that gives U.S. spy agencies the authority to collect bulk information about Americans' medical care, firearms purchases, credit card usage, and other interactions with business and commerce. The government can get virtually anything, says Senator Ron Wyden, Democrat of Oregon. He's a member of the Senate Intelligence Committee, so he's allowed to read many of the court's rulings, which are classified.
It is transparent. That's why we set up the FISA court.
Members of Congress from both parties are pursuing legislation to force the court's orders into the open. Critics say the court has undergone a disturbing shift created in 1978 to handle routine surveillance warrants, individualized, personalized warrants. Critics say it is now issuing complex, classified Supreme Court-style rulings that are quietly expanding the government's reach into the private lives of Americans. Judges on this court are selected from the pool of sitting federal judges by the Chief Justice. That's required by the law that established the secret court. President doesn't nominate them. There is no additional confirmation process. The surveillance court is a different world of secret case law, non-adversarial proceedings, and rulings written by individual judges who rarely meet as a panel. They generally confer only with government lawyers and out of public view.
It is transparent. That's why we set up the FISA court.
Yet the judges have the power to interpret the Constitution and set long-lasting and far-reaching precedents on matters involving Americans' rights to privacy and due process under the Fourth Amendment. This fast-growing body of law is almost entirely out of view of legal scholars and the public. Most Americans do not have access to the court's full interpretation of the Constitution on matters of surveillance, search, and seizure when it comes to snooping for terrorist plots, and are limited in their ability to challenge it. All 11 of the current members were appointed by Chief Justice John Roberts, 10 originally appointed to the federal bench by Republican presidents. The court's under-the-radar approach proved a particular challenge this spring to the Electronic Frontier Foundation when it sought to file a motion seeking release of the prior finding of the unlawful government surveillance that was under the Bush administration. It turned out the mere act of finding the court proved a steep hurdle. Repeated calls to the court clerk from the foundation went unreturned, says an attorney for the group, which wound up submitting the motion through a staff member at the Justice Department whose officials were actively opposing the group's efforts. Quote, "We never had any direct contact with the court," said the attorney for the foundation, and the other party in the proceeding was the gatekeeper.
It is transparent. That's why we set up the FISA court.
Mr. President, no due respect, are you kidding?